to him. List of items put into evidence and their numbers. Everything that was said about what we should consider and what not. Detective reports, need some way to watch and discuss videos. All right, I'm going to address that concern. I'll talk about it as I explain to them. They're entitled to consider the testimony about reports, but they have all the exhibits and numbers are on the exhibits, and so they just don't understand that. Example, what are we going to consider in testimony of the hearts? There wasn't any testimony. There was testimony about the hearts, but not from.
It wasn't from the hearts, but there was testimony about it.
Yeah. From witnesses. They want an easel also for to take back there. So let's bring in our jury, please.
It's pretty much just the same for the most part, but getting a couple of them that can easily adapt. First part, it's really probably standard, and then just add as parts that are specific. We'll have to revise and that each we'll work on that.
A lot of people say that.
What? It's a case, Judge, and they did it. It's Judge, Judge Thomas for review. Thank you very much, ladies and gentlemen. My was now court 63, and first said we'd like to give a definition of circumstantial evidence and reasonable doubt, what we can view and what we can't, hear the whole charge. What I'm going to do is this. We were talking about it, and several of my brothers and sisters on the bench have started to do it as a matter of course, and I'm probably almost there. I didn't know this until we all have to go to Reno to the National Judicial College, not to play the casinos, but I'll share this as an aside. I spent 3 weeks there, and the judges from all over the United States go to their colleges at the University of Nevada, and it's nice group, nice faculty. But one person, we were staying in the dorm. I think they've changed that, but somebody got on an elevator and said 3 weeks in a one-night town, and I thought that's probably good. If anybody likes Reno, I'm not trying to be offensive to that, but anyway, I found out that most states send the written charge back to the jury. We just don't in this state and haven't historically. We're starting to do it now, and one of the obvious reasons, if you're visual, I can read that charge to you from now till tomorrow, and you'll get some of it, but it won't be the same as you being able to look at it. And I understand the significance of that. It'll take me a few minutes to, my charge obviously, there's some parts of it, for instance, if I have a his and it's a her, so I'll need to get that cleaned up a little bit. Take me a few minutes to get that, but we'll get that back to you. The next is list of items put into evidence and their numbers. Everything that you have in your jury room is an item in evidence. The numbers are on there, the stickers, those are the numbers, that's the reference in the testimony. We try to do that. Sometimes we're not, I'm kind of particular about that a little bit, and I upset lawyers sometimes because they won't refer to the document as the number, but for the record purposes. But you'll know that. Sometimes you may not hear it on the record if you listen to the testimony, but you'll know that exhibit. Everything that was said about what we should consider and what not, I'm not sure I understand that question. I'm assuming this, because one of the things that I said was I mentioned about exhibits, because there were several exhibits, I think both sides used it from time to time, exhibits that were for identification only. They weren't actually put into evidence. They were used, and typically you heard the word demonstrative evidence, and that's what it was for. It was to help you relate to what was being said in the courtroom, but it's not in evidence. Now you can consider the testimony about that. You can consider, for instance, you said police reports. You can consider the testimony about the police reports concerning those questions, the witness rendered. You're just not going to have the police report itself. So that's the distinction. To use one example, and there were several times where that was referenced. Was it in your report? Well, you can consider the responses, but you don't have the report itself. If somebody's saying, I want to verify that, I understand that, but you don't have that, because your task is to decide this case with the burden that we talked about, to prove the burden of proof on the state, that you have to decide it on the evidence you have, okay? And that's what's been introduced, and that's what you base it on. If you recall, you'll read part of my instruction concern. Reasonable doubt may arise from the evidence, or the lack of it, or the absence of evidence. So that's how that all plays into it. But you can't, it would be nice, maybe the day will come, I think Arizona tried to do this for a while with jurors asking questions during a trial. It becomes burdensome, because somewhat difficult, because most of you probably haven't been trained in evidence in the legal field, and there are certain rules that allow some things and some things can't come in. So that's why the jury's tasked with deciding it based on what you have, okay? They need some way to watch it. All you need to do is tell me which videos you'd like to watch, and we'll bring you in and we'll watch those. But that's all. I just need to, you won't be able to do that in your jury room. You'll have to do that here. And the reason for that is sometimes, and I think in this one we have actual discs that were just the portion, the video, the whole video has much more information, but just to make sure, we'll play it in here for you rather than send it back. And we'll get you your easels. So with that additional instruction, if you'll return, and I will get you the charge as quickly as I can. Okay? Thank you. You may retire. Additions from the state.
Your Honor, as long as they know they can rehear any testimony as well,
They do.
the state's fine.
They know that. Okay. That's fine.
No, Your Honor.
Okay, thank you. They didn't ask for that. They asked for videos, is what I was just addressing what they asked for, solicitor. Thank you. And that's the reason I didn't go any further than that. But I think that's, I know I said it early on about the notes, but in my closing, I think that's what I said about reminding them that if any time they have a disagreement about what somebody said, or didn't say, we have the ability to replay that. So I know I stressed that before and at the end too. So, but thank you. All right, we'll be at ease.
Thank you.
John, would you like us, the attorneys, to stick in here, because you said you wanted to give us...
You can, but if you want to get out, I'll
Yes,
make
sir.
a copy and I'll leave it on your desk.
Thank you.
I'm done. Yeah, just give me 1 second.
Yes, sir.
Let me talk to you.